Okay, we're going to go ahead and get started with our last and final presentation for today, Contemporary Developments in International Space Law. Now, for those of you who don't know, Colorado Springs is considered Olympic City, USA. It's our official motto. And that's because the U.S. Olympic Committee is located here in Colorado Springs, as are many of the various teams, USA Basketball, USA Cycling. So we really love our Olympic sports here. And I'm particularly a big fan of the relay sports. And it's always fun to see who runs or who participates in the last leg of the relay, the anchor. Well, for our anchor here today, we have none other than Professor Frans van der Dunk, a great friend of the conference, and somebody we're very appreciative of taking his time to come here. Professor van der Dunk is the Harvey and Susan Perlman Alumni and Othmer Professor of Space Law at the Nebraska College of Law. And he has been awarded numerous awards for his work in the area of international space law and has served as an advisor to several governments, the European Commission, the European Space Agency, the UN, numerous national space agencies, the Center for Strategic International Studies, and was a member of the advisory group to the Permanent Court of Arbitration on the drafting of optional rules for arbitration of disputes relating to outer space. He is also the owner of Black Holes BV, a consultancy company for space law and policy. Perhaps most importantly, he was the sole lawyer on the panel on asteroid threat mitigation established by the Association of Space Explorers in 2007. So if it all goes wrong, at least we'll have the rules on who to sue. Over to you, Professor van der Dunk.
Thank you. I thought I had 60 minutes, but I see I have only 58 left, or can you reset the clock? Thank you for that very kind and generous introduction, and I think it's very courageous to put a law professor in between all of you and happy hour. Luckily, there are a number of my former students in the room, so I hope they defend me if push comes to shove. Anyway, many aspects of what I'm going to talk about have already been addressed in earlier panels of today, but of course, I'm very happy to add some broader and international context to that. So I hope you bear with me on that. It's probably fair to say, and now of course this should work. There you go. It's probably fair to say that there are four grand challenges to space law today. And I'm going to briefly run you through them, at least through my appreciation and interpretation of those challenges and what the law is trying to do currently about that. The first one is lunar exploration and exploitation. The second one, mixing military and commercial satellite operations, then satellite debris and going beyond that. And of course, we've heard a lot about space debris already. I want to take a little bit of a look beyond that, but I'm not going to go into too much detail because most of that has been covered actually today. And then finally, one of my hobby horses, national space legislation and the risk of fragmentation. It was very briefly touched upon by Dr. Swiney in one of his remarks. So in all cases, what we are talking about is to move from the general principles of the Outer Space Treaty to a more specific interpretation, implementation, application, what have you. And just to remind ourselves, the Outer Space Treaty going back to 1967 has 112 states parties, which is more than half of the world community. Then there are 23 states who merely signed, and if you remember your international law courses back from law school, that still means that those countries have an obligation to respect the object and purpose of that treaty. Most importantly, of course, all major spacefaring countries are included, not just the United States, but China, the former Soviet Union, now Russia, India, Brazil, the Western European countries, everyone who is something in space is a party to that treaty. And in addition, it is by and large, I don't want to go into the details, but by and large considered customary international law. On the other hand, it has been mentioned before, it is a principles treaty. It has a lot of general broad principles which require further elaboration, and for good reason, I would say. Final remark here, it is of course drafted in a Cold War area when only the United States and the Soviet Union really mattered in matters of space, which means that it primarily addresses the military use of outer space, even if only succinctly, and there was, for example, to point out to one of the four major challenges that I'm going to address, and to the other three, there was no serious consideration of space mining, space environmental issues, or the privatization of space, raising the need for national legislation. So how do you interpret these principles when these elements now are suddenly part of the international discourse? Well, we luckily have treaty interpretation tools, most importantly, the Vienna Convention on the Law of Treaties, which is not formally ratified by the United States, but recognized as reflecting customary international law on how to address treaties and how to implement and apply them. And this includes nominally the important element of subsequent practice in the application of the treaty as implying the proper interpretation and definition of relevant clauses and concepts. And this leads in many cases to national space legislation and other legal acts of individual states which express this interpretation of the Outer Space Treaty. And then there's something along the same lines in customary international law, where state practice and opinio juris taken together also reflects the interpretation of states of key principles of the Outer Space Treaty. So it's basically two separate ways of arriving at the same conclusion. If you look at what states do in a legal context, that helps us interpret these vague principles in that specific context. So now over to the four specific challenges: lunar exploration and exploitation. This basically started to be an issue in the early 2010s, when these two companies, Planetary Resources and Deep Space Industries, were interested in space mining. Side note, of course, at the time they were interested in asteroids, not in the moon, but legally speaking, the moon and asteroids are in the same legal basket. So we can sort of equate them for the purpose of legal analysis at this point. Their lobbying largely gave rise to Title IV in the 2015 US Act. In the interest of transparency, the University of Nebraska, my colleague Professor Schaefer and myself were behind the scenes involved in that whole discussion, which did a lot of things, but Title IV, of course, specifically addressed the issue of lunar exploration and exploitation. Then comes the Artemis program as a program launched in 2021, giving rise a couple of years later to the Artemis Accords. I'm going to spend a few more words later on. This is just a summary timeline. And then within a year, the Russians and the Chinese came up with their quote-unquote alternative approach to these issues. Now, the baseline legal issue is here. If you go back to the Outer Space Treaty, you only have Article 2 to deal with. That's the closest we have in the Outer Space Treaty to an article, to a specific legal clause telling us how space mining, exploration, and exploitation could take use. And if you look at it from a theoretical perspective, what does it mean? The flag of the United States was not planted there to claim part of the United States for part of the moon for the United States. It was simply to honor the US taxpayer, who of course ponied up all the money to get there in the first place. So that left us two generic interpretations. One is that you say, well, if outer space belongs to all of humankind as an interpretation of Article 2, that means all the resources there also somehow belong to all of humankind. And then there's the opposite interpretation, and of course this is a very black and white analysis, but I just want to give you the main dichotomy there. If outer space is considered something like a global commons, and I know a number of people in the US government hate that term, but I still use it. That's my privilege as an academic. And it means that all states are entitled to use that common area as long as they comply with the legal rules pertinent thereto, and as long as they can do so, they can also allow their private sector to benefit from those rules, which is what I would say the essence of the US approach. So in 2015, the US Act generated a lot of international discussion. Is this the proper interpretation of Article 2 of the Outer Space Treaty? Dr. Swiney already reflected to that. Well, first country was Luxembourg. And in the interest of transparency, as a consultant, I was involved in the discussions there, which created in 2017, I'm sorry for the formatting, which was a little bit screwed up here, created a law on the exploration and use of space resources. And because Luxembourg is a civil law country as opposed to a common law country, there are obviously some differences in the approach, but the baseline is the same. This is legal. A single country can license private operators to go to the moon or asteroids and start harvesting their resources. Then 2 years later, the United Arab Emirates, in the interest of transparency, I was also as a consultant involved in those negotiations, developed a UAE law, which did a lot of things. It was a law on generally regulating the space sector, but it included explicitly the possibility of going to the moon or asteroids to exploit and explore them. And then there was a third country, Japan, which in 2021 created the Japanese Space Resources Act. And as you can see, this, of course, also presumed the same approach. In the interest of transparency, I was not involved in the Japanese Act. I regret that because it would have notably brought in a lot of money. Now, not everyone was happy with the US approach, as you can imagine. One of the countries which was, of course, the first to protest was the Russians. And the Russians were angry. They didn't like this one bit. If you looked at the arguments they put forward at the time, when someone like, this is disrespect for international law by allowing the US private sector to sell something which presumably belongs to all of humankind. It is a new interpretation of the non-appropriation of space when the reality is that there was no other interpretation yet. It was the first interpretation. So new interpretation suggests that there's an old one, but that was not happening. This is a facetious one. Disregard for discussions in the context of the Moon Agreement. Those of you who are familiar with the Moon Agreement knows that it at least suggests an international regime of sharing those resources. The Russians didn't sign up to that either. So how they come to claim something on the basis of a treaty that they are not party to themselves is an interesting question. Then this moves into Cold War language. This is one other element of these US imperialists trying to dominate outer space through the veil under the ruse of competitive private enterprise. The freedom of outer space, of the use of outer space, finally was when the argument is not law, but the theory of experts and specialized fora. I would say read the Outer Space Treaty again. It's pretty clear to me. So the Russians were making a lot of hay about their opposition and their claims that this was not appropriate. Another country which was against this was Brazil. Brazil was not angry. Brazil was sad. Brazil was disappointed because they considered that this was an inconsistency between national law, allowing economic exploitation and the celestial bodies, and then the principles of the UN space treaties, which presumably, in their view, meant that they were not allowed to be harvested. Multilateral interests should take precedence over unilateral ones. Now, that's a statement which I can agree with, which actually the US also agreed with, because those of you who read Title 4 of the 2015 Act may note that one of the requirements in there was for the US president to promote the interests of the US in this context, in a global context, which essentially means try to convince the rest of the world that the US approach is right, because that is good for private commerce and good for all concerned. So that is a multilateral approach, which of course is better than if you are only the United States saying that this is the proper approach. And then they say, and this goes to the same point, domestic legislation is a poor substitute for a multilateral instrument. Then there was one more country which I didn't put a baby picture of, that was Belgium, which was also pretty vocal, but I'll come to that later. Let's go to Luxembourg. Why is Luxembourg interesting at all? It's a country largely the size of Greater Omaha, 350,000 people. You know, if they allow the commercial exploitation of lunar resources or space resources for that matter, you don't have much of a big market. But Luxembourg is a member of the European Union. And one important element of European Union law is this article, which reads that products which arrive in third countries for free circulation in accordance with the laws of that country can then benefit from the free trade regime across the EU. So now you're not talking about a potential market of 350,000 people who don't have a space station or any ambitions to go to the moon. Now you're talking about a market of 450 million Europeans, because Germany and France, and at the time still the UK, but of course they now are out of the game, Italy, you name them, they all have to accept that stuff mined from the moon or from asteroids is valid, legally valid subject material for trade and discussions. Now, this raises some international issues, and I'm sorry, as a European, I want to at least inform you a little bit of that. There are 3 countries in the European Union, and here you have their flags: Belgium, I mentioned it before, my country, the Netherlands, and Austria, who for several reasons in the past signed up and ratified this moon agreement, which, and I put here my own phrasing, paraphrasing of what it basically says, suggests that you cannot appropriate those resources unilaterally, that you should wait for an international regime of whatever sort before it's legal. So those countries, if push comes to shove, if there actually will be a possibility to mine those resources, will be caught between a rock and a hard place, because they either have to choose between their loyalty to the moon agreement, or maybe reinterpret it, or stepping out of the European Union. I think I know which, if push comes to shove, which choice they will make. So the moon agreement is an important one, because another country which has signed up to the moon agreement and actually ratified it as well is Australia. Australia is probably fair to say is the single true spacefaring nation which is a party to the moon agreement. They did that for political purposes back in the day. And also Australia is party to the moon agreement, so they will have a problem as well. And then the final country which I want to mention there is Saudi Arabia. Saudi Arabia is another member state, another party to the moon agreement, and they have chosen, interestingly, to conclude from their entrance into the Artemis Accords that it was not viable, not how do you say, not compliable with the moon agreement. So they stepped out of the moon agreement. Almost a year ago, they announced that's the first in outer space. It's the first time that a country which is party to an outer space agreement decided to step out of it, made this decision in the moon agreement, and that stepping out takes effect, I think within the next few weeks, or it may have already taken effect. It's somewhere in this time frame. In the interest of transparency, I had nothing to do with that, even though I did advise the Saudis on this. Anyway, that's a story for the happy hour, I guess. So the last country I want to mention, and it's of course been mentioned all over the place already, is China. And China is very interesting for a number of reasons. You could imagine that from a political perspective, they would take every opportunity to blast the United States and you know, go along with the Russian chorus of this is imperialism, stuff like that. But China has been on the fence. They didn't say anything officially, and there's a good reason for that, and that is this. It may well be that the first, and I think, again, Mr. Cheng in this case referred to that, it may well be that the Chinese will be to the moon before the US are, and if they start digging in the most interesting spots, and the US has promoted the idea that that's legally viable, you don't have a point to stand on. So this should be also a major incentive for the United States and the international level to try and get some form of rules applicable to how you approach the exploration and exploitation of the moon. Part of this will have to be informed by scientists who may tell us that certain parts of the moon are more interesting than others. Sometimes the comparison has been made with the geostationary orbit and the use of space frequencies, where we have been able as a world community to arrive at a system which works pretty well by and large in terms of allowing many countries, many commercial operators to use these frequencies and these orbital slots and orbits. But of course, it requires that there is a lot to be shared about. And just going back a little bit in the history of satellite communications, back in the 1970s, there was a major worry with the developing countries that by the time they would be technologically and financially able to go there and hang up their satellite in the geostationary orbit, all the fancy places would be taken. So if that happens on the moon, that is potentially a recipe for strife, maybe. So, but we need the scientists to tell us, are there just 5 spots, or are there 50 spots, or are there 500 spots we are of interest, which is going to be very crucial. Now, this is kind of the legal part of the discussion. Then beyond the law, of course, we have things like the Artemis Accords. We've discussed that in great detail, but just in case you missed that, it basically includes the freedom of space mining as a baseline for operations in the Artemis Accords. Artemis Accords, technically speaking, are not a treaty. So it's really a low level in terms of the legal binding force of this agreement. It's a low level approach to try and basically say, if you countries join us on the Artemis project, We are happy to do so. This is supposed to be an international feature. The Outer Space Treaty promotes international cooperation. But then, of course, we should at the outset agree on certain baseline principles. It's no good if once we are on the moon building our lunar bases, we then start fighting over the extent to which we can use lunar resources to do that. So it's in spite of the fact, obviously, and it has been touched upon, so I won't go into further detail, that as such, this is not a binding legal document. It may well evolve into customary international law. And somebody said that it's, I think it was Mr. Schweini again, said that it's shockingly successful. Well, it is, because this is the list, the latest at least I saw of the list, of countries that are members of the Artemis Accords. And let's highlight a few of those. Now, the ones which are now colored green are the obvious ones, because they have already national space law, as we discussed, which actually promotes and thereby certainly condones the private exploration and exploitation, subject to some form of licensing and authorization. So there's nothing spectacular in this one. But you also see Belgium and Brazil, two countries which back in the day, almost a decade ago, were vehemently against this. Apparently they have either come around on a legal point of saying we agree to this approach, or they think that this is the best for their economies to join the fray. Interestingly, moreover, we see three countries, Australia, Mexico, and the Netherlands, who are parties to the Moon Agreement. So they consider that the Moon Agreement and their requirement under international law to comply with whatever the Moon Agreement says does not necessarily interfere with their agreement under the Artemis Accords, that it's an okay principle to commercially exploit and explore the moon. But then there is Saudi Arabia, which, as I said before, took a different stance. Now, before we move on here, I want one more thing to point out. If you look at this list, what is in particular impressive, I think, from an international legal perspective, is that it binds countries from, let us say, all walks of life. Sometimes the comparison has been made to the International Space Station, which is also a huge international venture, 15 countries. But those countries are all 15 rich, highly developed countries. Here you have countries from all parts of the world. We mentioned Saudi Arabia, United Arab Emirates, and now there's also Bahrain from the Arab world. We see African countries. Nigeria is in there. Rwanda is in there. We see Latin American countries, Asian countries. So this body of countries, which is now party to the Artemis Accords, is by that token gradually building customary international law. I don't think we are there yet. Maybe we should wait some real state practice. This is what I call paper state practice, because it just means that you sign on to some paper principles. And of course, the rubber hits the road once we really start going there, start to exploit those resources. And maybe some of those countries may have second thoughts. So we will have to see about that. I mentioned the Artemis Accords, and I was not the only one, and I was also not the only one to mention the alternative approach by the Chinese and Russians predominantly, where the Chinese, I colored them in this strange combination of colors to make clear that in principle, they might not be so much against the same approach, precisely because they might well be the first ones to benefit from it. I think there's just two reasons why the Chinese will never sign up to the Artemis Accords. One is, of course, that NASA is legally prohibited to work at any substantial level with any Chinese because of political reasons. That's a legal obligation. And the other one is simply the fact, and it has been alluded to before, that the Chinese, from their political perspective, will never sign up to anything that was clearly initiated by the United States. Other than that, I haven't seen any text yet come out of this, but I would be very surprised if the Chinese would say you can only operate a mining exploitation exercise on the moon once we have a truly international regime. I have here a message of consolation for Gabriel Schweini. I'm not sure whether he's still here. The United States are not the only ones who suffer from being flagged for something that they put their name on. I remember that when the PPWT, this de-weaponization treaty discussion came on, the US was clearly against that. Also, the European countries didn't see much value in that. So they came up with an alternative approach, but it was called the EU Code of Conduct. So out was the US, no support. So just to point out that this happens more often in international politics. Now this is, again, I have to see what the legal or even paralegal or meta-legal or guidelines or whatever is coming out of this construction. In addition, it's interesting to note that Luxembourg, one of the most active countries in this field, at least on paper, has meanwhile concluded with agreements with a number of countries. And again, you see the green ones, logically. You see Belgium, which is the neighbor of Luxembourg. So probably it was because Luxembourg was so active that Belgium said, maybe we should join as well. And you see China there. So this also tells me that China is interested in international cooperation, of course on their own terms to a large extent, but isn't any country trying to do that, and is certainly not averse of working with countries which apparently condone the idea that you can unilaterally allow mining of the moon. Even the Russians at some time were discussing a bilateral agreement with Luxembourg, but of course that didn't go anywhere. And I guess, I think it's fair to say that the main reason they did that was just to try and get some influence left and right, maybe become closer acquainted with the precise argumentation and the precise reasons behind the Luxembourg approach. But anyway, that didn't go anywhere. So that's where we are right now. Maybe if if we congregate 5 years from now, we will happily come to the conclusion that everyone has agreed to the possibility to use those resources, but also then have come to agree to a little more substantial framework of how to make sure that no bad things happen out there, that it doesn't become a Wild West in practice. Now I move to my second subject. And here, there is a big elephant in the room, but I don't hesitate to bring it in. I'm going to use the case study of the Ukraine as the ultimate example of the problems that this may raise. And just to point out, to refresh our memories, a little over 2 years ago, this is what happened. Russia invaded Ukraine. They sort of killed the infrastructure of satellite technology, which the Ukrainians worked with, which was called Viasat. And then we had this Santa Claus called Elon Musk, who from the goodness of his heart then offered the use of his terminals to the Ukrainians. What is the baseline legal issue here? Well, it's a complex one. First of all, on the one hand, from the space law perspective, we have this Article 6, it has been mentioned before, which makes states directly internationally liable for private space activities, qualifying as national activities. And my good friend, Professor Beard, has already alluded to this. This was by the Russians because they did not want to allow the possibility that the United States could extend their imperialist capitalist domination. You remember the Cold War language, under the guise of private commercial enterprise. So they wanted to be absolutely sure that Elon Musk, I'm sorry that I'm picking on Elon Musk all the time, it's nothing personal, but that Elon Musk would be the responsibility of the United States. But it's more than that. It's not just responsibility, it's also liability. Article 7 in the Outer Space Treaty and then the elaborative convention of 1972 called the Liability Convention makes states also directly liable for the damage caused by those private activities for which they qualify as the launching state. And it then also vice versa allows them to claim damage caused to those private operators. So if Elon Musk causes damage in outer space, the bill will first land on the desk somewhere in Washington, I guess with the State Department, and the US has signed up to the Liability Convention and will be forced to pay. And vice versa, if something bad happens to Elon Musk, the US has at least the right, not an obligation necessarily, but the right to stand up for Starlink and ask for their damages to be compensated by whoever did the bad stuff. Now, this is only one side of the picture. The other side of the picture is that we talk about the law of armed conflict, of which I'm sure many of you are familiar with. So I'm a little bit on skating on thin ice here, but I think it's fair to say that private assets and activities could potentially form a legitimate target for the use of armed force if they concern private sector entities of a belligerent or otherwise substantively supporting one. Well, that of course raises the question, is the US already a belligerent, or do we have to move to the second part of the equation? and if such use would be compliant with principles such as military necessity and proportionality. I don't go further than that, unless you want to in the discussion. But the question is always, how do these LOAC principles apply to outer space? Because we know LOAC for centuries, if not even millennia, but most of the rules have been clearly developed on a domain-specific basis. How do you apply proportionality when a Starlink system is used for military purposes, but also for hospitals, for peaceful communications, for commercial operations? Where does the balance between commercial and military tilt? You don't have that in the traditional discussions on ships, which went with armed transport to help one of the belligerents. So now, in order to make things even more complicated, and again, I'm only summarizing this, on the basis of non-secret information. So this may include, I'm sorry, as a law professor, I have to add a disclaimer here. This may include stuff which in the end is just hearsay, but it's out there in the papers, and I certainly do not know all that's going on. So that's my caveat. But what I see is that there was a first phase initially in the war when the delivery of the terminals was only partly financed by the Ukrainian authorities. Most of the cost apparently went to Starlink. There was a free provision of services, largely at their expense, and it was used indeed for this complex combination of military and non-military purposes. So if you want to put a flag over that, I would say in practice, this was clearly favoring the Ukrainian side of the conflict, right? Oversimplifying, but still. Then things changed. There was an increased use for drone attacks. There were outages concluded. There was a separate service put aside for military services after contacts with the US DoD. Starlink limited access to its terminals to Ukrainian-controlled territory. So the parts of Ukraine which were occupied by Russia could no longer, drones or missiles flying into those territories could no longer make use of Starlink facilities. At least that's what the publicly available knowledge tells me. And then Musk also somehow got a little bit afraid, got cold feet. Or was it like a drug dealer who first gives out stuff for free and then after a few months says, hey, now you start paying, you need to start paying for my facilities, right? So if you want to put a flag over this, I think it's a mixed bag. You know, certainly there is a tendency to favor Ukraine in this context, but on the other hand, you are doing certain things which the Russians were clearly very happy with. And then, unfortunately, we are now in a phase 3. Musk, at some point, was told to have spoken to Putin. We don't know whether that's true or not. He later denied it, but certainly he got a little bit cold feet, even worse than he had already, because he thought, whether correctly or not, that Russian satellites, or that Russia might now start targeting Western satellites as being part of the Ukrainian war effort, going back to LOAC. Cyber attacks were directed against the terminals. The service in Crimea continues to be disabled. And I think this raises a lot of criticisms. Where is it really up to one guy to have such an incredibly important vote in whether the aggression of Russia in Ukraine should be countered or not, impacting basically to a large extent the US potential to do so. And then there's now even rumored to be Russian use of the Starlink system. So again, if you want to put a flag on this, I think it's unfortunately the Russian flag. But we can discuss that. So what are the legal issues? And I'm smart enough to only put them on the table and not going to give you any answers, because I don't think there are ready-made answers. But these are the questions that you have to discuss and have to think about. To what extent would the US be responsible and perhaps liable for Starlink's support to Ukraine? Under the laws of war, under outer space law maybe? To what extent would Starlink satellites present legitimate targets? That's an obvious one. To what extent would the US claim Russian, let me go just one back up here. Of course, there is still outer space law, which prohibits shooting satellites out of the sky, which might potentially only be overridden if they are clearly used for military purposes. So that brings us back to some form of proportionality discussions. How that plays out, I have no idea. But it is a risk. There's one lucky thing, certainly if the Russians start using Starlink, but even without, space debris does not discriminate. So if the Russians start shooting up satellites in outer space, and they need to shoot up a lot of Starlink satellites before they get really what they want, the debris may well hit their own infrastructure as well. We spoke about the last Russian anti-satellite test. Well, lo and behold, of the 6 or 7 astronauts on the ISS who, as a consequence of the risk posed by that test to the International Space Station, had to take refuge in whatever vehicle was moored to the ISS at the time, there were 3 Russian cosmonauts. So the Russians threatened their own cosmonauts. Now, I'm not putting it beyond Putin to risk his own cosmonauts if that suits his purposes, but it still tells you that if there's rational people out there, they might have a second idea about just destroying stuff, running risk themselves. Okay, to what extent, this is an interesting one, could the US claim then Russian liability for Starlink losses? Because it's a US operator, perfectly peaceful, at least presumably, or in defense against clear aggression. There's nothing wrong with that in international law. And to what extent might, even if you want to be out on a limb, the US be held responsible under international law for effectively allowing an aggressor to go its way? I phrase it a little more aggressively here, but you see the point, I guess. Okay, now luckily we at least have the WUMRA manual, which tries to address these issues. I'm not going to go in further detail because there are, of course, there's a session on the WUMRA manual tomorrow as well, I believe. But these are the 4 universities who are key to that. So that brings me to a less controversial point, but I'm also going to spend less time on it because it's less fun in a way. So that's space debris. Space debris, of course, many of you have seen this alarming picture, which is alarming. At the same time, we have to realize that all these pixels are grossly exaggerating. So obviously, each of them is supposed to reflect a piece of space debris, but it's not the proper size. It's mainly the speed with which they travel, which causes all those problems. Now, space debris is originally about broken pieces of space objects, or space objects which had run out of control, or maybe your screwdriver which was lost from the space station, things like that. But the whole issue, and this is what I will briefly spend a little bit of time on, is that this is now broadening into broader issues. We are now talking about space sustainability, of which space debris effectively is only one part. Of course, if we are clogged with all that space debris, there's no sustainable space operation. But there's more necessary than we can currently do with regard to space debris. And ultimately, we even talk about space traffic management. So the baseline issue is, legal issue with space debris is, of course, Article 9. We spoke about it in detail. I don't want to spend too much time on it. Article 9 basically requires, apart from this open-ended legal paradise of the concept of due regard. I mean, every lawyer can argue every which way what due regard is in any particular detail. The only requirement which is legally binding in there refers to consultation. On 2 sides, of course, the state which initiates an activity which could cause potential harm is supposed to consult with other states, and vice versa. States who believe that these other activities may harm their activities may request consultation, and that consultation should then take place. Now, of course, this was mentioned in 2007, where the Chinese, out of the blue, shot their Fengyun satellite. And I was told that at the moment that happened, the Chinese scientists, the civil scientists part of the Chinese Space Agency, were in an IADC meeting discussing measures on mitigating space debris. So the Chinese military clearly didn't tell them what was going on because they were hugely embarrassed, as you can imagine. Anyway, the only thing, legally speaking, that they did wrong at the time was to fail to consult. The fact that they blew up their own satellite, unless you can already argue that the obligation of due regard was so hard and fast that was violated, unless you can argue that, and I don't think you can, certainly not back in the days. The only thing that they really did wrong, internationally, legally speaking, was that they failed to consult, that they failed to give other states the opportunity to express their worries, maybe address these worries and try to be as nice as possible. This was exploded at, I believe, an altitude of 800 kilometers, and as was shown on one of the earlier slides today, the debris is still haunting us and will probably for another 100 years. So that's the major difference with what happened a year later with the downing of the USA 193, where the US did announce it in advance, where other states were able to express their worries, where the United States then took the measures to wait with shooting down until a fairly late moment, so that within a couple of months, I believe, all the space debris was literally out of orbit. So from that moment on, I think there was a positive development towards customary international law. There's a question mark there, and it was only development. Unfortunately, I will come to that. We spoke about that in some detail, but there are these IADC guidelines, which when they're elevated to UN level, COPOS level, still get more of a political, meta-legal, paralegal, soft legal value. And then there's increasing domestic implementation. And in this regard, I want to point to a book which has recently been published by one of the alums of University of Nebraska, Lieutenant Colonel Mark Carnes, who analyzed the policies and the laws in the US, European countries, ESA and the EU basically, China and Russia, on how, on paper, they started to implement these rules on the national level as part of the authorization system for private enterprise. So things were looking positive. There was a focus on LEO and GEO because that were the two orbits that were most in danger. And the main strategies were to limit the release of debris during normal operations. Don't let the screwdriver fall out of your hands if you're busy outside of the space station. Minimize the likelihood of in-space disintegration, implement technical measures so that they become a little bit more sturdy, but then not sturdy enough to survive re-entry, hopefully. Do some measures for post-mission disposal and avoid in-space collisions. But then, alas, the international climate turned worse. In 2019, we saw the Indians do their first target practicing in outer space to show that they were up with the big guys as well. And then the Russians answered within a few years. We've seen that before. Actually the very same picture. And as I said, this will threaten also 3 cosmonauts, although in the end none came to harm. So that brings us then to the resolution on the ASA test ban. It was mentioned, so I won't discuss it in any great detail. From an auditorium with a huge vote in favor, and already a number of states which actually followed the examples. But as I said, this whole development also of these renewed ASAT testing increased the worries and brought them to a newer level. And that's where the change sustainability comes in. Not just try to avoid the wanton creation of space debris beyond Article 9, but really try to establish a code of conduct. 2008, the first initiative was made. Guidelines for the long-term sustainability now are basically seen as the way to go, but they are not binding yet. And they impose a number of requirements which go well beyond the original focus, the traditional focus on handling space debris. I listed them here in my own terminology. As such, they take up a page and a half. So develop domestic policy and regulatory frameworks. Use the law as a tool, more specifically than hitherto, to make sure that you don't just address specific mitigation measures, but general oversight and supervision and control, even after launch. That you also include frequency use, which can also be in part of an accident in outer space, and enhance the registration of space objects, because that, at least in an ideal world, will allow easier identification of culprits who do wrong. Share information and data relevant for space operations, and this already precludes kind of, sort of presages the space traffic management discussion. Promote international cooperation and capacity building, and promote scientific and technical research. So a much more complete package than we used to have under the IADC guidelines. And then we are yet moving further discussions on space traffic management. But I must warn, we are facing here a lot of problems, legally and otherwise. And we have, of course, concepts like state responsibility and liability, registration, as elaborated by the Registration Convention, even the ITU regime, which sort of provide initial embryonic elements of such a future space regime. But how the heck do you realign some measure of binding space traffic management? We all think about air traffic management or maritime traffic management with the freedom of space activity. Do you think that sovereign states will subject that freedom to some organ who tells them where to fly and what to do if they're flying in outer space? Or the territorial sovereignty of which does not apply in outer space, but which does apply in national airspace. No one will contest the US right to impose any air traffic management measures in US airspace that it wants to, simply because US airspace is part of US territorial sovereignty. The only comparison we do have in international law is the international airspaces over the high seas, where for the greater common good, all countries in the world have agreed to, through ICAO, delegating the air traffic management responsibilities to one particular country or another. Iceland, for example, is de facto controlling a large part of North Atlantic airspace, and there's no American aircraft commander, pilot, who will contest the right of Iceland air traffic control to tell it to go higher or lower because of air traffic management considerations. But are you going to be applicable to do that in space? I think it's a challenge of cosmic proportions. Because first of all, we don't only talk about unmanned spaceflight. There's just a limited amount of human spaceflight going on, but most of it is unmanned. Compared to aviation, where you always have, until the UAVs come on board, of course, pilots on board who can actually maneuver and do certain things. We don't have that in space. What we do have in space is an International Space Station. Oh, did you see how fast? I want to do that again. Do you see how fast that moves? Things move incredibly fast in outer space. You cannot do that just by eyesight. If you're in an aircraft, you can probably still see an oncoming aircraft and at the last moment make an avoidance maneuver. That doesn't work in outer space. Then we have other satellites which are of different nature, different capabilities, different orbits. Some are orbits which follow the curvature of the Earth, but we also have highly elliptical orbits which cross that all the time. And then, what was my next? Okay, they are controlled from the ground. So this is where the radio frequencies come in. But that's not all. Probably the majority of what we need to be concerned with is what is already out there and is totally uncontrollable. It's not just unmanned, it's totally uncontrollable. It's space debris, which then can create more space debris. I had a lot of fun making this slide, as you can imagine. But just to make the point, apart from strictly international law and political obstacles, you have to address issues of speed and size, which are totally different compared to air traffic management. And this is, of course, where space situational awareness is going to play a major role. The majority of space objects is not only without humans, but has a difficulty in maneuvering, you know, anywhere close to the maneuverability of aircraft, even unmanned aerial vehicles. And then the majority of non-human carrying space objects is not controlled anymore. Okay, I stop there. I don't have the solutions, but I just want you to be aware that this is going to be really a massive task where at some point states might have to step over their own shadows. But then I move to my last part, and that's the privatization issue and a potential race to the bottom. And just to refresh our memories, for the first decade and a half, probably nobody seriously saw any money being made in outer space. But then roughly in the 1970s, there were some private commercial companies who saw the potential for commercial benefits in running a satellite service operation. In 1980, with the establishment of the first commercial launch provider, Arianespace in Europe, and a few American competitors, you started to get an embryonic global space launch market. In 1985, you see the first efforts to commercialize satellite remote sensing. Of course, there were a lot of problems, and probably only now we are at the cusp of a really commercial area. But there were private companies already involved since 1985. And then now we have things like the efforts to suborbital and even orbital spaceflight. Your Virgin Galactic and Blue Origin and SpaceX flights for what we call space tourists, but are formally to be called spaceflight participants. And maybe soon we will see active debris removal, on-orbit servicing, space mining, and all that. So why do I mention that? Because the basic legal issue is here again, Article 6 of the Outer Space Treaty, which now in a peaceful context still makes states internationally responsible for private space activities, as long as they qualify as national activities in outer space. And it actually requires those states responsible for them to authorize and continuously supervise those. I'm sort of skimming over some of the intricate details here. There are some flaws if you read the Outer Space Treaty, which make it a little bit inconsistent here, but this is basically what it says. And then, of course, we also have Article 7 of the Outer Space Treaty and the Liability Convention, which means that, again, if Elon Musk crashes a rocket into Mexico, and that rocket causes $1 billion of damage, that bill will first go to the US government. And since we have recognized an unlimited liability in the international context, that $1 billion of damage has to be paid to Mexico. So this clearly does not oblige, strictly speaking, but it provides a huge incentive to authorize and supervise, in my case, Elon Musk. Because you want to make darn sure that, first of all, he knows what he's doing, payload reviews, launch reviews, what have you. And then second, on the legal part, you include the obligation to reimburse the US government for any international liability claims that the US government has to pay out. And then actually you are also required to provide insurance against that. So that brings us to the issue of national space legislation, which includes then a system for authorizing and continuing supervision and handling international state liability, providing a mechanism whereby the state can go back to any licensed operator and say, your activity now means that I have to pay out this amount of dollars to a foreign entity, foreign country, I should say, and now you have to pay me back, at least up to a certain extent, because that's, of course, a policy choice, whether you want to translate that unlimited liability on the international level one-on-one to the operator. The US has taken the choice not to do that. So that's where the maximum probable loss and all these complex regulations of the Commercial Space Launch Act comes in. Now we're going to play a little bit of fun with flags. These are the countries which up to now have a national space law in place which prominently includes such a licensing system, and almost all of them deal also with liability. So let's just take a few examples. You see, of course, the United States, you're not first, you're second. Norway in 1969 was the first who created a national act saying that if you launch from within Norwegian jurisdiction, you need the authorization by the Norwegian government. It's a phenomenal act. It's just half a page long. Very simple, very straightforward. The US came second because I put the date of 1970 there because that was the moment that the Federal Communication Commission formally recognized and made clear to the rest of the world that the authority that they already traditionally had for authorizing any telecommunications operator in the context of the US also applied to satellite communications, because that authority went back to a 1934 act, which clearly as such didn't mention satellites. So 1970 formally is the birth of national authorization within the US of private sector operations. We see obvious countries like the UK, France, though a little bit late in the game for typically French reasons. We can talk about it later if you want. But you also see China and Russia following the falling apart of the Soviet Union and at least the formal introduction of capitalism. You see Japan, but you also see a number of interesting countries. Here's Kazakhstan, which is the basis of Baikonur, and after a number of years started to think, well, maybe we should commercialize Baikonur and allow anyone willing to pay to launch from there. Does anyone recognize the last flag in the list? I see no hands. That's Liechtenstein. It's a country the size of, well, maybe the area of Colorado Springs. And yet they feel it helpful for their industry, for the development, to allow for the registration and the licensing of satellite operators. Of course, not launch operators. Nobody's going to launch from Liechtenstein. But that's the extent what we're talking about now. And of course, that runs the risk of fragmentation. Now, in some cases, we see that in practice, there is a harmonized approach. If you talk about the scope of who should get a license under these regimes, almost anyone applies it to nationals or anyone operating on national territory. And usually they also add anyone operating from what I would call quasi-territories, ships or aircraft with national flags. Almost all of them include an obligation to reimburse the government or liability claims. I mentioned that already. And they often then, while they're at it, also address national international third-party liability claims. In the US Commercial Space Launch Act, formally it doesn't even talk about international claims, it talks about all it talks about all third-party liability claims. That is something which you see happening more and more. And usually, not in the case of the US, as we heard Dr. Swiney explain, a single government agency is either established or appointed to deal with that. But then there's also a lot of fragmentation going on in terms of what type of activities these regimes address. There's a large variation. Again, in the US, you have for each specific activity a separate regime, but some countries don't go beyond launch operations or satellite communications operations. Canada and Germany are well known for only applying their authorization regime to remote sensing satellite operations because of security considerations. Many states have no proper authorization regime at all, because impressive as these, this picture of flags was, there are still many countries which don't have one. Think about India, for example. And then the details of these regimes are wildly varying. Now, maybe that's not something to be worried about too much, although it might incentivize some foreign shopping. Insurance is sometimes mandatory, but most of the times it's not. Sometimes you find caps inserted in the acts or the statutes or the laws, sometimes not. And if it is capped, you sometimes find a fixed cap. For example, France has a standard cap of 60 million euros per launch, which at the current rate is some $65 million. And sometimes inter-party or contractual liability issues are also addressed. In the US, there is a law which requires contracting parties not to sue each other in case of damage under that contract for the launch. So this raises the issue, and has been mentioned briefly before, of cheap flags and license shopping, where the most important, the only case so far, was the Space Bees in 2018, where a US company didn't get through the licensing loopholes of the FCC and said, you know what, we're moving to India, but they didn't escape the long arm and were ultimately punished for that. One good thing here, and I want to end on an optimistic note, is that we think about flags of convenience as, in the law of the sea, as resulting in these enormous risks of accidents, of oil pollution, of beaches, and the killing of fish and all that kind of stuff. Well, there are two things which make it much less likely that, at least in the launch area, we will have cheap flags convenience. One is what I would call the beauty of space law. Since states are fully responsible and liable for compliance with international law and the damage that would be caused by launches that create damage, they will look out much more closely as to what to license, and not license any idiot who thinks he can do something interesting in outer space. That's different from the law of the sea, right? There is if you have a tanker registered in a cheap flag country and that tanker creates a huge oil spill causing millions or even billions of dollars of damage, it will be very hard for you to sue the country. You have to try and sue the company, which by that time is probably broke anyway. So that's the beauty of space law, that you directly can address the states. And there's another beauty, and that's the reality of the space business. If you are a country which is confronted with a request of a shipping owner who says, I want a license with you because you don't require my captain to know what he's doing if he's steering the boat. You don't require double hulls. You don't require separate parts of the tanker. You just want a marginal fee, and then we carry your flag. If that country then says yes, it will be relatively certain that when bad things happen, they will happen elsewhere. 95% of the coast that will be spoiled by an accident by such a cheap tanker will be coasts of other countries. Not so in the launch business, because the launch business is still the most dangerous part of space operations. So if something goes wrong with a launch, it will likely hit your own country. And this again, hopefully at least, presents a huge incentive for countries to be not too easy and too quick with licensing foreign operators and just allowing them to do whatever the heck they want. So again, I want to leave you with that slightly optimistic note, and thank you for your kind attention. And we have time for questions, I think, right? Or, well, it's up to you. Happy hour calls, right?
We do have one question from our online audience.
Yeah, they can join the happy hour. So.
Absolutely, yeah. Maybe they've already begun. Article 2 of the Outer Space Treaty forbids national appropriation. The questioner asks if the nature of the Artemis missions being multinational, largely multinational, is there an interpretation with regard to that mission, mining notwithstanding, that could be used to interpret it as non-appropriation for those purposes under Article 2 of the Outer Space Treaty?
I would basically turn that around. Can you argue that certainly if you leave out the utilization part, that any mission which even if it occupies the moon for a certain period of time is completely in compliance with international space law. There's a treaty article which basically says that the freedom of outer space activities means the freedom to establish facilities on the moon, as long as they are not military. That's the main caveat, of course. But you can establish any facility on the moon, and the right to visit, which Professor Beard briefly made reference to, was partly initiated in order to make sure that those rights were not abused for military purposes, a kind of a confidence and transparency building measure. So the mere establishment of a facility as such does not go against the grain. But there's of course a catch there, because you know, if it stays there for 5 years, nobody will have a problem, I guess. If it stays there for 10 years, maybe. If it stays there for 50 years, I'm sure there will be a number of states that start complaining, well, you now effectively occupy the moon. And while you may still legally act as if you're not the sovereign, 50 years of you telling everyone else what to do there amounts to being a sovereign. So somewhere there, in between there, you move from the right to free establishment to an obligation to honor the possibility that someone else would maybe occupy that spot. The least I think you can say is that if you then, you know, leave the bases apart, if you go back home and say, well, we're no longer interested, then that opens certainly the door for others to use that place again.
One more question from our online audience talks about the law as it relates to failed launches, essentially going into neighboring countries. What would be your thoughts and your advice with regard to a country that would trigger this question in recent memory?
Okay, can you repeat that question?
Have we lost a space launch vehicle that went into a neighboring country recently? And what will we do about it from a legal perspective?
Well, if it's actually crashed, there will be a liability claim. And luckily, we haven't had that before. And fingers crossed, it will take a long time. But unfortunately, with the increasing launch frequency and the increasing number of satellites and other operations going on there, and then if we add in the mix, the soon to arrive number of human space flights, which start maybe being suborbital, but some of these operations, at least in the long run, and that aim at flights using space to fly in 2 hours from New York to Tokyo instead of 12 hours, or to deliver stuff in outer space. That's where you really need to start worrying about creating some better rules of the road. Then it's not nice to have an accident and say, okay, you now have to pay so many $1 million. I'm not sure that's the answer that the person is looking for, but you're satisfied with it. Okay, then I'm too.
So the liability convention essentially establishes kind of strict liability and perpetuity for the launching states. Is there anything to prevent a launching state from withdrawing from that convention and then avoiding further liability of objects already placed into space when that country was part of the convention?
You know, the moment you step out, that's when you stop engaging in potential new obligations as the launch. Having said that, that supposes that rule is not customary international law, whereas I would say there's a strong claim that based on Article 7, which is part of the Outer Space Treaty, which is by and large agreed to be customary international law, you cannot even get out of that obligation. And when you talk about strict liability, I need to add that applies only to damage caused on the ground. So that's where strict liability, and it remains in perpetuity, and that raises some complex issues going back to the fact that back in the 60s when these treaties were drafted, nobody really thought about these possibilities. The idea was you launch a satellite or something in outer space and it will be yours forever. The possibility that at some point in time, somebody else might be interested in buying your satellite, some other country or its private operation, which as such does not qualify as a launching state, raises interesting issues because the liability is in perpetuity. So suppose the US launches a satellite, it's clearly the launching state, and then after 5 years, Norway says, we want to buy that satellite, here you got a ton of money, and then they take over the ground control, and then yet 2 years later, that satellite crashes. Guess who's liable? Not Norway, under the liability convention, but the United States. Which means, of course, that by contracting with Norway in the contract of sales, the United States needs to be darn sure that Norway promises in such an event to pay back that damage. In space, however, when it comes to space damage, there's a fault regime, which has, nobody has ever thought in any detail about what fault means. We're still struggling with that. Luckily, in a sense, because it means that we had only really one clash in outer space. That's the Cosmos-Iridium clash of a number of years ago, where this issue was raised at all, and then both parties kept their silence. As one side note, partly because the liability pertains to the launching state. In the case of Iridium and the Cosmos satellite was a Russian satellite which had run out of control 10 years before and then crashed into the Iridium satellite. The Cosmos satellite was clearly launched from what was the Russian launch port in Baikonur in Kazakhstan. Iridium was a private commercial satellite of a private commercial US operator. But guess where it launched from? From Baikonur. Because they had a better deal from Baikonur. So does Russia go against Russia? How does that work? So both parties reserved their rights. And another interesting question was, if you look at faults, again, you can interpret fault many ways. The Russian, let me put it this way, the Russian satellite had run out of control. So the Russians had nothing to try and make that satellite change orbit or whatever to avoid crashing. The only ones who could do a maneuver was Iridium because they had a live satellite. They had asked for a conjunction analysis with the US agencies who were doing that. They came to the conclusion, no, it's not going to crash. And then it crashes. So does that make the US the liable state for that? I mean, all sorts of questions, right? I'm sorry, I'm going well over time, but thank you for that.
All right. Thank you very much, Professor von der Dunk, for ably running that anchor leg and bringing us to today's finish line. I don't have a medal for you, but I do have the 2024 4th Annual U.S. Space Command coin. So thank you very much.
Thank you.